White-collar crime is a greatly expanding area of the law. There have been numerous well-publicized cases, from Enron to Allen Stanford to the recent spate of insider trading cases. Now, what is a white-collar crime? Basically, it is a crime committed by a businessman, thus the white collar. Now, it can run a variety of different types of crimes. Lately, insider trading seems to be one of the hot areas. But we've also seen, of course, the corporate accounting tricks and bank fraud, mortgage fraud, Medicare fraud, and any other type of fraud. Now, there are several dangers in this white-collar arena. The first danger, if you've been under investigation or you've been indicted, is that there is often a very fine line between what is an aggressive business practice and what is a crime. And it usually boils down to one issue, that is the intent. Whether or not somebody had fraudulent intent at the time they were engaging in certain aggressive business behaviors, or whether they were simply an aggressive businessman. And so there is always a built-in defense to these types of cases. That is, I may have done most of the things the government says that I did, but I did not do them with criminal intent. I was simply a businessman acting in the best interest of the company, and I was a loyal employee simply doing what I should have been done. And although perhaps in hindsight I may have done some things that perhaps I shouldn't have done, I may have been overly aggressive, at no time did I have the intent to defraud either any shareholders, any individuals, or anybody else. Now, one of the great fears in the white-collar crime area is the huge sentences that are often given. When I first started doing the white-collar work back in the early 80s, before there were federal sentencing guidelines, it was almost a given that somebody who committed a white-collar crime and had no prior criminal record would receive probation. And this would be particularly true if they had engaged in charitable activities, they were a leader in the community, and the types of things that you would always or usually find with white-collar defendants. However, with the advent of the federal sentencing guidelines in 1987, it was a real game changer. All of a sudden, guidelines came into effect that gave extraordinary prison sentences for first-time white-collar offenders. As a matter of fact, in certain financial crimes now, the guidelines will actually call for a life sentence without parole for a first-time offender. Because of the dollar amount of the fraud may be in the billions of dollars, not millions of dollars. It may involve international connections, abuse of position of trust, numerous victims, and other enhancements under the federal sentencing guidelines that create an extraordinarily lengthy sentence. This is often used by the government as a tool to coerce guilty pleas. There is a severe penalty paid in white-collar cases for one that insists they are innocent and demands a trial. And it's most unfortunate because one is presumed innocent, they have the right to a trial, and they should not be penalized by asserting that right. Yet that's the way it works in the real world. There is a trial penalty. Whereas if somebody works with the government, they may get a sentence of 5 years. If they go to trial and get found guilty, they may get anywhere from 20 years to life, virtually coercing somebody into pleading guilty. Now, white-collar crimes carry many different hurdles that other types of crimes don't have for the criminal defense attorney. For one thing, there are literally now, oftentimes in discovery, millions of documents that are provided by the government. In a recent case that I handled, there was a database that had over 10 million documents. Virtually impossible for an attorney to review 10 million documents. You have to have a team and a system to be able to find the proverbial needle in the haystack, because that's the way the government provides the discovery. They don't provide the key documents, and even if they did, you couldn't rely upon them to provide the helpful documents to the defense. So therefore, the defense has to go literally through millions of pages of documents with a system to try to find those key documents that are important. One of the other things that's important in a white-collar case is to be able to present the evidence in an orderly fashion. That is, to be able to present charts, diagrams, and simplify it for the jury, as well as to be able to present the documents in a meaningful way where you can highlight the critical things in the documents. Therefore, it's extremely important to get an attorney that is skilled in handling white-collar criminal cases, cases that involve millions of pages of documents, cases that involve sophisticated accounting, cases that require CPAs and other financial experts. I have been handling these types of cases for over 20 years and have handled some of the largest white-collar cases in the country. If you are in need of a white-collar criminal defense attorney, make sure that you find someone experienced in handling these unique types of cases.